My Lords, in dealing with the technical argument raised by the respondent, if there were any doubt as to the application of the 1981 Validation Act, the specific substitution of subsection 2, giving a new expiry date to the 1941 Act, makes it clear that the 1941 Act remained in force until 23rd February 2002.
You say it has a sort of retroactive effect?
In effect, it does, because many of these validation acts, my Lord, were actually passed after the expiry date. And this one is no different and is the last one.
Is this the only one which has the effect of substituting a section like that, or a subsection?
No, the previous acts have.
Yes, I guess that this looks as though it's replacing one which said it expired in February 1999.
Yes. Yes, Malone friend refers me to tab 5 in his bundle. I haven't included it in mine, my Lord, because I did not take the view that there was some sort of gap in the continuity of the Act, but Learned Friends tab 5, section 2, is in similar terms. And in answer to my Lord Roger, yes, the combination of sections 3 and 4 are intended to ensure continuity, and therefore it does have retrospective effect. It has never been understood to have any other effect, but simply to keep the 1941 Act in force.
I think Mr. Rowe says that it only refers in section 3 talks about acts and things done or purportedly done. He says, well, what are we talking about here?
Well, my Lords, it may be, for example, purporting to validate acts undertaken by the rent restriction boards, for example, which were constituted by the Rent Act. And, of course, if they have no authority, then they must have authority from this. But the consistent theme in all of the jurisprudence relating to the Rent Acts, both in England and other parts of the Commonwealth, has always been that the Rent Act legislation was designed to protect the tenant. I simply adopt that line of reasoning here because if, because of a default by Parliament, it's to be suggested that Bim Ramdass, the father of the appellant, had no protection for a 5-year period, that would be, in my submission, not simply extraordinary, but manifestly unfair, because it has been applied, or the 1941 Act has been applied, as recognising statutory tenants or protected tenants under the Act in that 5-year period. There is no case I can take your Lordships to, but certainly when your Lordships look at the first decision I'm going to seek to distinguish, the case of Dehaney, that decision was delivered in 1984. Again, purporting to apply the 1941 Act.
What happened in the legislation between 1987 and 2000? Were there resolutions?
There were further resolutions, similar to the Act I've taken your Lordships to keep it going until 2002.
Not legislation, resolution?
It's in effect various statutes passed, and they can be categorised as resolutions. I would accept that, my Lord. My Lords, I don't propose to address your Lordships any further on this point. Can I assist your Lordships any further on this? My Lords, the second point my learned friend raises, which I have to deal with, is the application of the Rent Restriction Exclusion of Premises Order 1954. The submission, in short, is because the appellant did not plead when the house was built, it may have been excluded by this order. Again, it is simply wrong. The exclusion of premises order was designed specifically to encourage building of properties by landlords and making those properties available for tenants. If I can take your lordships to tab 3 in the Learned Friends bundle, this is the orange bundle, this sets out the subsidiary legislation. Reliance is placed on section 1 of the order, which reads, as from 12th February 1944, all new buildings, the erection of which was completed on or after that date, together with any land appertinent thereto, and to be occupied therewith. Now, he relies on section 1, but I'm afraid that it's the section 2 which informs how section 1 is to be read. Section 2, specifically 2b, explains that the erection of a new building means, and this is on the next page, page 26, the erection of a new building shall be deemed to have been completed on the date on which the first tenant or occupier enters in possession of the said building. This order relates only to landlords who have built a property on their land and then let the building. It does not apply and never has applied to land tenants who only rent the bare land. I was able, my lords, to obtain the extract from Hansard, Friday, 12th of February 1954, and your lordships, I believe, have that. And simply to put the matter to rest completely, I would draw your attention to it, if I may. This was the, it's a treasury tagged item, my lord. I believe it was put onto your table before you came in.
Yes.
Yes. My lord, this is the extract from Hansard dealing with the rent restriction exclusion of premises order, left-hand side of the page, page 1073. The next page...
This is the Legislative Council or something?
This, yes, my lords, because in 1954 it was the Legislative Council rather than Parliament, which was one of the lawmaking bodies. If your lordships turn over to the very next page, you will see that the pilot of the bill, the Minister of Education and Social Services, the Honourable R.A. Joseph, moves the motion that the Council approves the rent restriction exclusion of premises order 1954.
Yes.
And if I can invite your lordships to turn over to the very next page, 1076, I can take you straight away to what was meant by this order. And it is the first 10 lines on page 1076, left-hand column. And the part that I draw your attention to is this. The government felt that there would be abuse of this recommendation, and so we modified it to apply to houses and dwellings rented after the coming into force of this ordinance. The operative words being houses and dwellings rented. This order was never designed to apply to the land tenant who had built his own house and was only renting the land. And again, it has always been understood in that way. Yes, yes, of course. Take that.
Yes.
My Lords, moving on, again to deal with this point conclusively, could I invite your Lordships to turn to the case of Dehaney, which is in the Appellant's Bundle of Authorities, tab 13.
Yep.
And to take your Lordships to page 9 of the decision of Dehaney, to page 9 on the top of the page. The very last paragraph, my Lords, on page 9, deals with the point my learned friend raises as to the exclusion of premises. In seeking to draw a distinction in this particular case, Justice of Appeal Macmillan said as follows: I would seriously question the opinion advanced by counsel as the purpose for which the 1981 Act was passed, since tenants of building land were given protection under the Rent Restriction Act, and this the important part, and I am not aware that any of the orders made under Section 4 of that Act, excluding premises from its operation, applies to building land. My Lord, the key phrase there is building land. This refers to the land tenant, as opposed to a tenant who has rented a building.
Yes.
My Lords, moving on to the next point I must deal with. My learned friend served a supplementary case, which I think your Lordships have seen this morning. It's entitled Supplementary Case for the Respondent. Where the argument the respondent raises in support of their case is that the Rent Restriction Dwelling Houses Act from 1981 has application to the appellant. It does not. Can I take your Lordships, please, to the Act itself, which is in the respondent...
My understanding is that your learned friend was performing his duty of drawing to the attention of the board something that might be relevant, even though it appeared to be against him. If you say that it doesn't apply to your client, I don't think Mr. Rose can have any difficulty with that.
Very well. My Lord, I know that we had a brief discussion in the roving room before. I simply wanted to point out, my Lords, that the reason I have not drawn it to your Lordship's attention is that it has no application to land tenants, and that's the only reason I have not addressed it. But since my learned friend is indicating that it may have application here, it's simply to point out as a matter of law it doesn't.
Oh, why did you say that? Just explain to us.
Well, my Lords, if you look at the Act, which is in tab 7 of the Respondent's Bundle, and turn to Section 3 of that Act, the first two sentences in that, well, the first two lines, rather, put the matter to rest. This Act applies to all dwelling houses which were let for a rent, whether payable monthly or not. So it's specifically designed to attach to dwelling houses which were made available by the landlord for tenants for a rent, not to land tenants of building land.
What do you mean by a land tenant?
My Lords, I'll take your Lordships to it in more detail in a moment, but the short point is this. A land tenant never rented a property on the land. He simply rented the bare land. As part of the rental agreement, he built his own house on the property. A building tenant, a distinction has been drawn because the landlord himself has developed the land, erected a dwelling, and let that to the tenant. And that is where the distinction in Trinidad has been drawn, which led to the passing, I'll show your Lordship in a moment, to the Land Tenant Security of Tenure Act 1981. It's a particular and peculiar problem to Trinidad and Tobago, which is why they had to legislate specifically for it, because the Rent Restriction Act legislation worked an element of unfairness. That is, that the land tenant, having rented the bare land, graded it, cut it, put in drainage, water, electricity, then raises it to a status of development which increases the value of the land so much that if the landlord were permitted to take it at the termination of the tenancy, he would profit immensely from the development of the land. He wouldn't, for example, need to obtain planning permission to build a property. It was already erected on there. All he would need to do is to take the property that is already on there, and if it is a wooden house, as applied in this case, you could simply renovate it in concrete. You wouldn't need planning permission, no permission for electricity or anything like that. The value to the landlord then is as a result of the hard work of the tenant.
Yeah, well, I think we can all see that. So you say that it is a tenancy of bare land,
Yes.
where the tenant positively binds himself to build a house, do you?
Yes, that is in effect the purpose of renting land at that time.
And who owns the house?
The tenant. This is why, my lords, in this particular case, you couldn't order the possession of the land without ordering compensation for the house. And in this particular case, compensation was ordered for what was inaccurately termed the chattel house. And that is the normal order made when a land tenant is put off the property upon which he's erected a house. The building is not owned by the landlord. I know it seems odd, my lords, but I can take you to the extracts in the debate which demonstrates why the 1981 Act had to be passed to deal with this.
That is the theory you're advancing that here, in a case, supposing you lose, that the respondent becomes the owner by paying the compensation?
Yes.
Is that...
He simply compensates, as the order made in the High Court says, the tenant, the appellant for the chattel house, and he takes the land with the house on it. That was what the 1981 Act was designed to change.
But is this jurisdiction to grant, to make an award of compensation, is that a statutory jurisdiction?
No, my lord, I don't believe it is.
It's a creation of Trinidad common law, is it?
It is in effect, because it was always recognised that the tenant who had improved the property should have some compensation if he was ever put off the property to build another house. In this particular case, they didn't even call expert evidence. They simply took a figure based on the oral evidence given by the respondent and appellant and ordered compensation.
It's funny that the Attorney General, in explaining the bill that became the 1981 Act,
yes,
he explained the problem about true chattel houses that you could put on the back of a
yes,
lorry, and chattel houses, so-called, which you would destroy if you tried to move them. But
yes,
he didn't say anything about compensation at all.
No.
In his explanation of the law.
No, he did not. And my lords, one of the difficulties even in this jurisdiction we have to deal with is sometimes when they focus merely on the chattel house, which was the focus of the debate and protecting the tenant of the chattel house, he may have missed that part of it, that compensation aspect. But it has become normal practice, if ever a land tenant were put off his property, to order compensation to the tenant for the house, because it is recognised that that does not belong to the landlord.
And that was common practice when the Attorney General was
Yes.
speaking?
Yes, my lords.
And he is to be presumed to have been aware of that?
There is a great deal I would say they should be presumed to know, but very often it's not at the forefront of their minds, my lord. But I accept he didn't mention it. I can't.
But if a land tenant was entitled to compensation, even if he had positively entered into a covenant to build the house, it doesn't strike me as an obvious social injustice that should be the position. But the 1981 bill was introduced because it was regarded as a great social injustice.
Yes. Yes, ma'am. My lord, I've dealt with my learned friend's last point. Can I now turn, please, to the application of the 1981 Act.
So you're put in brief, you say that this Act doesn't apply.
It doesn't apply.
The Dwelling Houses Act.
It doesn't apply.
So you would put it aside then?
I would simply invite your lordships to put it aside. If your lordships say that the exclusion of premises order and this Act suddenly applies to land tenants, it will be the first time. But I hope that I've taken your lordships to sufficient detail in both the debate, the Acts, and the judgment that it doesn't apply to land tenants. And that's the short point in relation to those Acts. My lords, can I take you please to tab 2 in the appellant's bundle? The Land Tenant Security of Tenure Act, page 4.
Yes.
My lords, the definition of chattel house on page 4, bottom of the page, and it is a statutory definition, includes a building erected by a tenant upon land comprised in his tenancy with the consent or acquiescence of the landlord and affixed to the land in such a way as to be incapable of being removed from its site without destruction. My lords, this was the focal point of this legislation, a house that couldn't be removed from the land without destruction. The next definition, existing tenancy, doesn't elaborate on what tenancies it applies to, but simply says means a tenancy to which the Act applies as subsisting immediately before its conversion to a statutory lease. My lords, we submit that at the very outset, existing tenancy, as defined here, does not exclude a statutory tenant, and never did. Moving, please, to the definition of landlord. Landlord is defined as any person who, under a contract of tenancy, is, as between himself and the tenant for the time being, entitled to receive the rents and profit of the land, and includes his successors in title. And my lords, the interesting part of this definition is that it defines a landlord, meaning any person who is under a contract of tenancy. I say it is interesting because a landlord under a contract of tenancy, by this definition, wouldn't apply on the conventional application of the rent tax to a statutory tenant because he has no contract of tenancy. He has a statutory tenancy. It cannot be read as limited to a landlord who only has a contract of tenancy. It must be read, in my submission, as including a landlord in his former capacity under the contract of tenancy. And that makes sense, my lords, when you look at the definition of tenant, which refers to any person entitled in possession to land under a contract of tenancy, but then goes on to include, after the semicolon, a tenant at will and a tenant at sufferance. The relationship at common law between, as your lordships know, between a tenant at sufferance and a landlord is not based on a contract of tenancy. So, simply by looking at the definitions, it is clear that the definition of landlord and tenant is to be drawn widely, not restrictively.
I mean, it defines, it adds to what you might think was a tenant under a contract of tenancy. Adds that this definition includes, a definition of tenant includes two things, tenant at will, tenant at sufferance.
Yes.
It doesn't say tenant, statutory tenants.
No, it doesn't. And I accept, my lords, at the outset, it doesn't specify statutory tenant.
The opening words of the section anyway say unless the context otherwise.
I'm sorry?
The opening words say unless the context otherwise requires.
Yes. Yes. And I say that the context in this case requires the courts to include a statutory tenant. But again, help can be obtained from section 3, which follows thereafter. Section 3, subsection 1, ensures that the Act applies to tenancies in respect of land on which a chattel house used as a dwelling is erected. Now I pause there, my lord, that would include Bim Ramdass, the appellant's father, in this case. And as I relied upon in my printed case, subsection 2 sets out an exhaustive list as to which tenancies do not apply. And it is this exhaustive list, my lords, applying the opening words in section 2, unless the context otherwise requires. This exhaustive list puts beyond doubt that a statutory tenant is not and should not be excluded. The Act is not drawn in such a way as to say what is included. It is only drawn in such a way as to say what is not included. But we can take it further in subsection 4 on the next page, page 6. My lords, subsection 4 deals with the conversion of tenancies to statutory leases.
I think it's section 4, isn't it?
Section 4, my lords, on page 6, top left-hand side. And before dealing with the length of the lease, the opening words to section 4, subsection 1 are, notwithstanding any law or agreement to the contrary, but subject to this Act. My lords, if there were any doubt left as to whether a statutory tenant would be excluded, the phraseology, notwithstanding any law or agreement to the contrary but subject to this Act, in my submission, puts beyond doubt that it is the 1981 Act that must be given precedence over any other law, including the creation of statutory tenancies under the 1941 Act. As I say, this Act was drawn to be as wide as possible, with the focal point on tenants who had built houses on land.
Presumably at the time of the passing of this Act, there were a great many statutory tenants
There were.
in Trinidad and Tobago.
There were. In fact, the debate refers to thousands at the time of the bill being debated.
Well, is it merely incongruous that no explicit reference is made to statutory tenant in the legislation?
I prefer to use the phrase, my lord, is that it was an oversight, that it was not included. When I take your lordships to the debates, you will see that the inclusion of the phrase tenants at will and tenants at sufferance only occurred because of a comment made by the leader of the opposition. And the response to it was that it was not needed. You did not need to include tenants at will or tenants at sufferance because it was already caught by the Act. So, at the very outset, when one looks at how this legislation came into being, the pilot of the bill contemplated that it would apply to every tenant who had built a property on rented land. My Lords, can I turn to the case of Dehaney, which is at tab 13 in the appellant's bundle. And these are the two cases which I must distinguish. In this appeal. My Lords, if I can take your Lordships to page 2, top of the page, of Dehaney. Halfway down the page, beginning with the word subsection 2. This, I submit, my Lords, is the first error by the Court of Appeal. It says subsection 2, which excludes certain tenancies from the operation of the Act, is immaterial to this case. Well, my Lords, it was never immaterial because it sets out the exhaustive list as to who is not included.
Well, it sets out a list of tenancies that are not included.
Yes. The second error, we submit, my Lords, is on page 4. Bottom of the page. And it seeks to draw a distinction between an appellant who is in possession under a contract of tenancy and a tenant who is not. The short point being that if you do not have an active contract of tenancy, you are not protected by the 1981 Act. My Lords, the way in which the definition of tenant has been read and applied thus far is, we would submit, inaccurate. If I can take your Lordships back to the definition of tenant in tab 2, this is tab 2, page 5. What has happened following the passage of the bill is that the words entitled in possession to land have been merged with under a contract of tenancy. And again, I'll take your Lordships to this in a moment, but when this bill was originally contemplated, the primary consideration would be a tenant being in possession of land, and then lists various categories which that would include, one of them being a contract of tenancy. Another being by assignment. The third being by operation of law. And the fourth, a catch-all provision or otherwise. Regrettably, and it's not clear the reasons why this occurred, when the definition of tenant was drawn for the Act, the colon and the Part A, Part B was removed and it was all put together. But oddly enough, as I'll take your Lordships to in a moment, the purpose was to widen the definition as originally framed, not to narrow it.
The Act doesn't very often use the word tenant in the sense defined in section 2. It mainly be used in connection with the statutory lease.
Yes.
I've been looking through it to see where it can fit into the definition, where one needs the definition in section 2. It's very rarely.
It is. It is. It might even be categorised as Lord Justice Scrutton categorised the early rent restriction legislation as not drawn as precisely as it could have been.
Well, I think it's a different one. I'm trying to see whether your extended definition of tenant, where it's necessary and whether it works.
My Lord, of course, I would submit to you that it does work for the purposes of my argument, but does your Lordship have a particular provision in mind?
No, I don't, because as I go through it, it's nearly always used in a different sense.
Yes. The reason for that may simply be, my lord, is that as it was contemplated, every tenancy that was converted into a statutory lease by this Act, you then had to define, well, what would apply to a person who is now a tenant under a statutory lease. And so the Act, the remainder of the Act focuses on that and defining those rights. So subsection 5 deals with the terms and conditions of statutory leases, 5A, the review of rent, and various other remedies and rights under statutory leases. So I agree that the focus of it is on tenants who now have statutory leases.
Do I understand you to say that the final subclause in the definition of tenant was introduced as a result of a remark by someone in the debate?
Yes, yes. And I keep saying I'm going to come back to it. I'm going to take your lordships to it, but the short answer, my lord, is that the leader of the opposition said, well, we have other things in our law, tenants at will, tenants at sufferance, and things like that. And because of that throwaway comment, as it were, the Attorney General piloting the bill said, well, they would be included in our definition anyway. But then at a later stage, the Attorney General said, well, to meet that comment, for the avoidance of doubt, if you like, we will include tenants at will and tenants at sufferance.
But the original bill ended at the final semicolon, is that right?
Yes, that's correct. That's correct.
And do you say that if that had been the enacted provision, that statutory tenants could be comfortably accommodated within it?
In relation to?
In other words, if the definition had ended before the words "and includes," for my part, I find it difficult to see how statutory tenant could be accommodated.
Well, my lord, this is where I have to distinguish the case law, because the Act, the definition of tenant, if looked at as it is, doesn't expressly say a statutory tenant is included, and I accept that. But what the definition of tenant does say is that it includes a tenancy, so-called, that comes into effect by operation of law. Now, my lords, a statutory tenancy, by definition, only comes into effect by virtue of the 1941 Act. It comes into effect by virtue of statute law. The nature of a statutory tenancy is to preserve the rights and obligations and terms of the original contract.
But
now,
I'm sorry, but the words "by operation of law" refer back to the interest of such person being acquired, isn't that right?
Well, my lord, no. The argument that I'm trying to mount is simply this, that the categories that have been created by this should result in a tenant being any person entitled in possession to land, 1 by contract of tenancy, 2 by assignment, or 3 by operation of law, or 4 or otherwise.
But that's not what the provision says, is it?
It doesn't expressly say so, and I appreciate that I am inviting your lordships to adopt a purposive or strained interpretation. But since the focus of the Act was always the chattel house, it is an interpretation which, in my submission, your lordships should apply here, to include the statutory tenant. The argument did not find favour with the Court of Appeal below, and that I accept, but in my submission that has to be wrong, because it would be an extraordinary state of affairs if, while the land tenant is paying his $16 a year, he would suddenly get a statutory lease, but that if the landlord serves a notice to quit, he could lose the substantial house he's built on the property simply because the landlord has terminated that yearly tenancy.
Is your argument that all you need is Section 3 and the definition of existing tenants?
My lord, the primary argument is yes.
And
yes.
the definition of tenant is
That is correct.
Particularly because the word tenant is almost never used in the whole Act in the sense defined.
Yes.
I've only so far only found one, and that is section 5(3)(b).
(5)(3)(b).
Yes.
Yes. I hadn't focused on that particular use of the word tenant in the Act, my Lord, but I do say that really by virtue of subsection 3, subsection 2, which sets out the tenancies to which the Act does not apply, it puts beyond doubt that a statutory tenancy is not excluded.
The difficulty I have with that is that at the end of the definition of tenant, there's the provision which says tenancy shall be construed accordingly.
Well, again, I'm stuck with the definition of tenant in the statute, my Lord, and that is the difficulty, and that is probably why the Court of Appeal has decided these cases as they have. They have restricted the definition of tenant and tenancy. The short point in answer to my Lord Rogers' comment is that because the focal point was the chattel house, and because the definition of tenant was intended to apply widely to protect the chattel house and the land tenant, the definition of tenant here should not be construed restrictively. That is precisely what the Court of Appeal did in Dehaney. And if I can take your lordships to that now, which I say is the next error. This is page 11 in tab 13, top of the page. And this, I think, is my Lord Rogers' point. Page 11a, tenant, which has a restricted and specific meaning in the Act, unlike the broad definition it has in the Rent Restriction Act and Rent Restriction Dwelling Houses Act, includes a statutory tenant under the Restriction Act. So, in considering the use of the word tenant in the 1981 Act, they have said it's a restrictive and specified meaning. But of course, Justice of Appeal Macmillan did not have access at that time to Hansard and could not have referred to it for the purposes of considering whether in fact Parliament intended the definition to be restricted and specified as he said here.
So you say you've got to say it's ambiguous what's in the...
It is ambiguous, but I can take it further that if it doesn't apply to statutory tenants, it leads to absurdity. And it's on those two bases that I invite your lordships to revisit the way tenant is defined. And going to section 3, subsection 2, helps your lordships in my submission to reformulate it in the way intended. My lords, can I take your lordships back to page 9? I move from this. This is the final error I submit occurred in the case of Dehaney. And it's the very last paragraph where Justice of Appeal Macmillan considers that he would seriously question the opinion advanced by counsel as the purpose for which the 1981 Act was passed. Well, my lords, not to unduly criticise the Court of Appeal, very often the difficulty in considering the purpose of legislation by courts is that they only have the legislation. Now that we have Hansard, it can be demonstrated that the purpose which Justice of Appeal Macmillan had in mind was incorrect.
But I'm not sure I've followed exactly what he's saying. What's he saying?
In effect, he's saying that the Act of 1981 does not appear to apply to tenants of building land who had already got protection under the Rent Restriction Act. That's the short point. But one of the interesting things about this decision, my lord, is that even though we know that the Rent Restriction Act at various stages had an expiry date, that doesn't appear to have featured in the reasoning as to whether, in fact, the 1981 Act intended to apply to Rent Restriction Act tenants whose rights may expire on the expiry of the 1941 Act. And it's interesting because when I take your lordships to the next case, there is a conflict between the two judgments given, where on the one hand, the first judge, former Chief Justice Sharma, indicates that the purposes of the 1941 Act and the 1981 Act are different and not intended to give the tenant double protection. But then the main judgment delivered by Justice of Appeal Hamel-Smith clearly contemplates that it was intended to protect Rent Restriction Act tenants. And can I take your lordships to that now? This is tab 14. The case of Edwin Alexander versus R. Sat Rampasad. My lords, the very first page, Justice of Appeal Sharma sets out a short summary of what he considers to be the starting point for the law. And 3 lines down from the beginning of his judgment, he says this: I do not think that it was the intention of Parliament to provide a statutory tenant with double protection, that is, under the Rent Restriction Act, Chapter 5950, and the Land Tenant Security of Tenure Act, 1981. He then goes on to say that help can be derived from the circumstances that gave rise to the 1981 Act, and that they were far different to the circumstances that gave rise to the Rent Act. Well, again, my lords, not to criticise unduly, they did not have access to Hansard at that time, and so the purpose or the background to the 1981 Act has been inaccurately stated in the judgment of Hamel-Smith that follows. But in distinguishing the case of Dehaney, that particular passage I've taken your lordships to is the first error in my submission in this judgment of the Court of Appeal. The facts of Edwin Alexander are not dissimilar to the facts in this case, but the very last paragraph on page 2 of the judgment contradicts, in my submission, what Justice of Appeal Sharma said in the opening of the judgment. Justice of Appeal Hamel-Smith's second sentence states, the main object of the Act, that is the 1981 Act, was to allow a tenant of land who had constructed a dwelling house thereon a measure of security, and these the important words, over and above that provided by the Rent Restriction Act. If Justice of Appeal Hamel-Smith is correct in this aspect of his judgment, and I submit he is, then it must follow, as night follows day, that a statutory tenant must be protected, because he is a tenant under the Rent Restriction Act. And the 1981 Act would provide that measure of security over and above that which he had under the Rent Act. My lords, taking you to the very next page, second paragraph, this is where Justice of Appeal Hamel-Smith purports to summarise the background to the passing of the 1981 Act, saying that the Act was introduced against a background where many tenants of land found themselves faced with a predicament that, having erected a substantial dwelling on building land, the leases or tenancies of which had expired or were about to expire, the landlords were under no obligation to renew the leases. With the result, such tenants stood to lose their dwelling houses with no legal entitlement to any compensation from the landlords. Well, first of all, the very last sentence is not quite accurate because the courts normally, as the law has developed in Trinidad, order compensation for what became termed as the chattel house, if ordering possession in favour of the landlord.
Are there cases to that effect?
My lords, no. I can only refer your lordships to the High Court decision here, where the order was in fact made for compensation for the chattel house.
Yeah.
I can, if I can make a note of it, my lord, I can... compensation. My lord, I've made a note of it. I'll
Yes.
see if I can get those
Thank you, sir.
cases for you. The second paragraph is interesting because it, in effect, says that the Act was introduced to assist people whose leases or tenancies had expired. Now, a statutory tenant, by definition, is a person whose contractual tenancy or lease has expired. So even applying the logic that Justice of Appeal Hamel-Smith set out here, that must at a minimum include a statutory tenant. My lord, the next error in this judgment is at page 5, I submit. This is page 5, bottom right-hand corner of the page. Here, Justice of Appeal Hamel-Smith considered that the words entitled in possession are used in a technical sense. And then goes on to...
Do you accept that?
No, my lord, I do not, because whenever phrases or particular words are used in a statute and considered to be used in a technical or specified sense, they are defined. As your lordships have now seen from the 1981 Act, the phrase entitled in possession is not defined.
But if you use a familiar legal phrase, is it a presumption not that it's got that usual meaning?
Yes, and what I submit is that the usual meaning of entitlement in possession is someone who is entitled to possession at that material time. The phrase entitlement in possession, I would submit, is wide enough to include a statutory tenant. I appreciate, and I'm going to deal with this, that the courts in dealing with the status of a statutory tenant have used the phrase a status of irremovability. They've shied away from using the phrase he's entitled to possession. My lords, that may have been a helpful term in the 1920s, but what does status of irremovability really mean for the purposes of a tenant who's in occupation of a property? My lords, in my submission, applying a simple common sense approach, entitlement in possession means that you are entitled to possession of that property, and a statutory tenant must be included in that. To describe that entitlement in possession as a status of irremovability is to fix the statutory tenant with the status of a concrete bollard. It is something much more than that. And in my submission, I can show your lordships that the pioneer of the Rent Restriction Act legislation recognised that...
Sorry, it's my fault, but can I just...
Sorry, Marilyn.
Can I just be clear? Do you say that when it says entitled in possession to land under contract of tenancy, that means entitled to possession of land under contract?
My lord, I say that contract... Let me phrase it this way. I say that the entitlement in possession is the opening word or opening words of the definition. It then sets out a number of categories, category number 1 being a tenant who's in possession by virtue of a contract, contract or a contract of tenancy. So the entitlement in possession must be read first. That is the starting point. A tenant must first be entitled to possession. And then it sets out how he's entitled to possession, category 1 being the contract of tenancy.
Sorry, forget the under contract of tenancy. You say that entitled in possession to land simply means entitled to possession of land. Is that what you're saying?
That is what I'm saying, that it means you are entitled to possession at that time, and then it sets out the categories of that possession. I have to acknowledge, my Lord, that this was an argument raised in the courts below in the cases of Dehaney and Edwin Alexander. It was not accepted then, but in my submission, that approach was wrong, and I hope to demonstrate that now. My Lords, can I take you, please, to the case of Herman, which is in the appellant's bundle. Forgive me. If your Lordships would bear with me for just one moment.
Number 18, maybe?
Lords, to keep to one bundle, because I will refer to another case, could I invite your Lordships to look at the respondent's bundle? It actually has the case of Keeves and Dean in there, and I'll take your Lordships to that first, if I may, to illustrate this point. This is at the respondent's bundle. Sorry?
Well, I'm sorry, we've burdened the court with so many bundles of authorities. It's this one, which is, it looks like a proper bundle, but it's much smaller than my friend's.
This is the one.
Another orange one, is it, Mr. Rowe?
No, it's not the orange one. The orange one is quite
Oh, yes, thank you. Now, got it. Yes, thank you. Red, back.
Yes, my Lords, this is tab 1. If I could invite your Lordships to turn to page 694, the judgment of Lord Justice Scrutton.
Yes.
My Lord, middle of the page, where Lord Justice Scrutton is seeking to define the status of the tenant, he says this, and I'm summarising, Parliament has certainly called him a tenant, and he appears to me to have something more than a personal right against his landlord. I take it that he has a right, as against all the world, to remain in possession. I emphasise the words, my Lord, in possession, until he is turned out by an order of the court, and that he could maintain trespass against any person who entered the premises without his permission. And then goes further and says it doesn't matter much what he is called. My Lords, in defining the status of the statutory tenant, Lord Justice Scrutton has, in my submission, stated the position accurately. It is not a status of irremovability, but a right to remain in possession, albeit a personal right, that he can maintain against the landlord and against the world.
Is he discussing the legislation as it appears on page 686, which talks about tenants retaining possession?
Sorry, 686, my Lord.
Yes, it's in the footnote.
Yes.
Retains possession.
Retains possession.
Retaining possession, giving up possession.
Yes, that is correct. And I'm going to take your Lordships to this now, but this provision, which is in the footnote on page 686, is in almost identical terms in the 1941 Act. And before I move on to the rest of the case, can I take your Lordships to tab 1 in the appellant's bundle of authorities, just to illustrate that point? My Lords, this is tab 1, page 21, top right-hand corner, section 15 of the Rent Restriction Act. page 21, section 15, is in exactly the same terms as the section my Lord Collins referred to in the footnote of Keeves and Dean. Subsection 1, a tenant who under this Act retains possession of any premises shall, so long as he retains possession, observe and be entitled to the benefit of all the terms and conditions of the original contract of tenancy, so far as the same are consistent with this Act, and shall be entitled to give up possession of the premises only on giving such notice as would be required under the original contract of tenancy, but notwithstanding anything in the original contract of tenancy, a landlord who obtains an order for the recovery of possession of premises or for the ejectment of a tenant retaining possession, as aforesaid, shall not be required to give any notice to the tenant. My Lords, looking at this as we are in 2009, the Act clearly contemplates, for the purposes of a statutory tenancy, that if the landlord is not entitled to possession and he has to obtain possession by virtue of an order of court, someone else has it. That someone is the statutory tenant. The phrase status of irremovability, as opposed to an entitlement in possession as a matter of law, is a phrase which, now having read the case of Keeves and Dean, seems to have been one comment by the junior judge on the day, Mr. Justice Lush. Could I invite my Lord Collins referred to page 686, but that in fact is the page where Mr. Justice Lush makes this comment. Could I ask your Lordships to look at page 686 in Keeves and Dean again? And this is the second to last paragraph in square brackets, Lush J. His interest seems to be nothing more than a status of irremovability. But if your Lordships look at the way Lord Justice Scrutton dealt with it at page 694, which I've already taken your Lordships to, Lord Justice Scrutton clearly had something else in mind, and it is Lord Justice Scrutton's explanation which is to be preferred.
Well, Lord Justice Banks seems to have been closer to Mr. Justice Lush.
Yes.
690, his right is a purely personal one.
Yes. My Lord, again, I accept that in the 1920s this may have been the phraseology used, but can I offer this perhaps more accurate definition? And it's simply this: a statutory tenant has a non-transferable right to possession. That is how, in my submission, your Lordships can and should view the right of the statutory tenant in 2009, a non-transferable right or entitlement in possession. It does no violence to the status of irremovability, but in my submission states the position more accurately.
Mr. Justice Lush's considered view is at 697.
Yes. He goes on to, well, this is why I say, my Lord, that it was a single comment made by Mr. Justice Lush, because the phrase status of irremovability doesn't feature in the judgment Mr. Justice Lush gave. He simply says at page 697, he has no estate in the premises that has come to an end, and all that the statute has given him is a purely personal right to be free from disturbance by his landlord. It is a very valuable right, but it is personal to him, a non-transferable entitlement to possession.
So you're not arguing that it could be bequeathed?
No, my Lord, I've considered that very carefully. I know in my printed case
So that part of the
argued.
case is fallen.
I don't argue that. And as your Lordships now know from the extra documents, the will and purported transfer of the tenancy is one under the 1981 Act, and that is why I say that's the primary submission in this appeal. My Lords, even in the subsequent case of Herman, again, this is the tab 2 of the bundle your Lordships are looking at, the respondent's bundle. Page 54, Lord Justice Banks' decision. Middle of the page, my lords. Tenant has been used, forgive me, this is tab 2, my lords, page 54, Lord Justice Banks' decision in Remon. Middle of the page, tenant has been used in a special and peculiar sense, and as including a person who might be described as an ex-tenant, someone whose occupation had commenced as tenant, and who had continued in occupation without any legal right to do so, except possibly such as the acts themselves conferred upon him. The legal right, my lords, is a right that comes about by operation of law. And in the way in which I'm inviting your lordships to consider reading the definition of tenant in the 1981 Act, it is consistent with the purposes of the Act to read the definition of tenant as someone who is entitled in possession by operation of law, and that law being the statutory tenancy.
But that's again said in the context of the provisions probably at page 50, footnote. Which is obviously referring to a tenant holding over.
Yes, yes, the same section and the equivalent that I've taken your lordships to in the 1941 Act. My lords, to give an indication as to in support of my submission that your lordships should give effect to the intention of Parliament of the 1981 Act, it's helpful to refer to the next page, page 55 in Remon. Where, in that case, counsel was seeking to argue in such a way as to restrict the application of the then 1915 Act. And in dealing with it, section 15, his lordship said this: if each of these sections is to be treated separately, there is much force in Mr. Romer's contentions as to the literal construction to be placed upon the language used in them. They cannot, however, be so treated. They form part of the statute, and they must not only be read together, but as forming part of an entire whole. And however much the draftsmanship of the Act may be open to criticism, the court must endeavour, and this is the important part, to place a reasonable interpretation upon the statute if the language used admits of such an interpretation. And then this, again important, to accept Mr. Romer's construction would be to rule out a large number of cases which the legislature must have intended to include, as, for instance, all the cases of tenants in occupation by virtue of the previous rent restriction acts. And I pause there, my lord, because even when construing the rent restriction acts in the 1920s, the courts have adopted a progressive and purposive approach in ensuring that those entitled to be protected were protected, even though it may result in a strained construction. In the instant appeal before your lordships, if the definition of tenant is not construed to include statutory tenants, then the intended protection by the legislature in the 1981 Act will not be given its fullest effect. And the approach adopted in Herman is an approach, in my submission, your lordships can properly adopt in relation to the 1981 case, the 1981 Act. My lords, again, to assist your lordships in approaching both the definition of tenant and the status of possession in the 41 Act and the 1981 Act, can I take your lordships to page 58 of Herman? And this is now the approach adopted by Lord Justice Scrutton. Top of the page, a tenant who by virtue of the provisions of this Act retains possession of any dwelling house to which this Act applies, and the framers of the Act were obviously under the impression that some provision of the Act did entitle a tenant to retain possession. Now I pause there, my lords. The approach adopted by the Court of Appeal in Trinidad is to rule that the tenant, the statutory tenant, has no entitlement to possession. He has this status of irremovability. But looking at the cases of Keeves and Dean, Lord Justice Scrutton clearly contemplates that if the landlord doesn't have possession and the tenant is entitled to retain it under the Act, the tenant has possession. Later on, middle of the page, going on to deal with the weekly monthly tenant. If this was not so, every weekly or monthly tenant, the small tenant for whose benefit the Acts were obviously framed, was outside the Act. So here, my lords, the Court of Appeal has adopted, again, a purposive or strained approach to ensure that the tenants designed to be protected or intended to be protected by the legislature were, even though on a literal interpretation of the then Rent Restriction Act, it didn't potentially apply. And then he goes on to say, unless tenant includes a former tenant by agreement holding over against the will of the landlord, and letting includes the landlord's relation to such a tenant, the whole object of the Acts is defeated. My lords, the approach of the Court of Appeal from Trinidad in Dehaney and Edwin Alexander has combined to defeat the purpose of Parliament by adopting an overly rigid and technical interpretation of tenant. If there were precedent for your lordships to adopt a purposive approach, it is there in Remon. And if there were any doubt left about it, and this last page I'll take your lordships to, the very next page, page 59, Lord Justice Scrutton again, third line, dealing with the statute, I do not think it has expressly, that is not expressly set out, that this particular tenant was included, semicolon, and I feel that I am straining the language in speaking of a person whose tenancy has expired and who stays in against the active protest of the landlord as a tenant and of the landlord's relation to him as a letting. But this is the important part, but such a person appears to be within the clear intention of the legislature. So, my lords, that...
Which he, of course, was deriving from the other provisions of the Act,
yes.
the overall
yes.
working of the Act. And you are saying, do I understand it here, that we can find it from what you're going to show us in Hansard?
Yes, and again, just to follow up on my Lord Rogers' observation, when one looks at Hansard, which of course none of the constitutions of the Court of Appeal, even in the 1920s, could do, they didn't have a very useful perspective, which is the true intention of Parliament. What was it that Parliament was trying to achieve? My lords, I've taken
You've made that point several times, but even before Pepper and Hart, courts always asked themselves what was the general legislative purpose, what was the mischief that the Act was looking at, and that's what the Court of Appeal seems to have done in the two cases that you showed.
They have, and but without, as I say, looking at Hansard. They've certainly considered the intention of Parliament as they could discern it at that time, but they did not look at Hansard, and I accept what my Lord Walker says, but that is what I would like to take your lordships to now, if I may.
And you're going to show us in Hansard not the general legislative purpose, but a passage dealing particularly with the meaning of tenancy, are you? Because that's all that Pepper and Hart really covers, isn't it?
Well, my lord, Pepper and Hart deals with two things. It deals with the construing of a provision, yes, but it also deals more widely with the question of absurdity or anomaly. If the construing of a particular provision would lead to an absurdity, then it would be proper to look at other aspects of Hansard to see whether it has a bearing on that.
No, you have to find ambiguity or absurdity to go to Hansard at all.
Yes.
And when you have gone to Hansard, you have to find something that unambiguously deals with the difficulty that you're addressing.
Yes, I do. And I submit, my lords, that I can show your lordships that, and if I can take your lordships to that now, and I'll come back to the case of Edward Alexander, if I may. My lords, the first extract in Hansard is at tab 4. And as your lordships will see from page 1804, and the page numbering is in the top right and top left-hand corner of these pages, this bill, or the precursor to the Land Tenant Security of Tenure Bill, was initially called the Chattel Buildings Bill. As I said at the outset, the focus of the 1981 Act was not so much the land, but protecting the building upon which, the land upon which it was built.
So what is this bill?
This is the Chattel Buildings Bill, my lord. The Chattel Buildings Bill, and I'll take your lordships to it as we go through, was the original draft of what became the Land Tenant Security of Tenure Act. So it's the same piece of legislation we are looking at. The name was changed.
Only the name was changed?
I'll tell you, lordship, just bear with me for a moment, Miles. I can take your lordships to it.
Anyway, you say it's got some bearing on the...
My lords, yes. If I can take your lordships to tab 6, and I'll answer my Lord Rogers' point now. Tab 6, page 506, top of the page. This is the Attorney General. Mr. Speaker, instead of the long title, An Act Relating to Certain Chattel Buildings, we propose the following title, which reflects the real intention of the bill, An Act Relating to the Security of Land Tenants. Sorry, I'm on page 506.
Yes, no, so that really does show. Yeah, thank you.
That deals with it. So it's the same bill we're talking about. Can I take your lordships back to tab 4, page 1804. And this, the bottom of the page, the Attorney General explains the normal meaning of chattel house, which can be removed from the land. That is strictly the legal definition of chattel house. And then paragraph, over the years, the practice has developed in Trinidad at least, or more so in Trinidad than in Tobago, of the construction of chattel houses in ways which have rendered their removal virtually impossible without irreparable damage to the land. And as lawyers will tell you, that has certain legal connotations with legal results.
Was it irreparable damage to the house rather than to the land?
Yes. It's, I think the reason, well, my lords, I know the reason, and I offer this submission to your lordships. What happened prior to 1981 is that when orders for possession were made and the house had to be removed, because it was a permanent structure, it would result in pulling up the foundations from the land, and that was sometimes the order made by the court. And then the landlord would turn around and say, right, you've now damaged my land, I want compensation for that. And that, I think, is what the Attorney General had in mind here. But it's not the focus of the bill. He then goes on to explain, third paragraph, through the years we have had these problems because they differ fundamentally from the strictly common law textbook definition, which we have inherited from the common law of the English legal system. And then, if I can take your lordships to the top of page 1806, top right-hand corner, and this is the statement which I think will assist your lordship. Second paragraph. The bill is limited in its application to buildings which, 1, were built or were in the process of being built before this bill is put into operation as an act by tenants on land of their landlords with their consent or their acquiescence, and 2, are incapable of removal without destruction. Such buildings, by reason of their irremovability, as such without destruction not only to the buildings, but without destruction to the land, are in fact part of the realty of the land, or the land, and as such are not in the nature of a chattel, which may either be of the nature of pure personality or the tenant's fixtures, that is to say, fixtures constructed or put up by the tenant with the intention that they should be removed by the tenant during the continuation of the tenancy or at the expiration of the tenancy. Pausing there, my lord, there you have the intention of the bill, what it was designed to protect. 7 lines from the bottom of this particular column, The strict rule at common law is that once a tenant constructs a building on the land, the building goes with the land, and at the end of the tenancy, the building belongs to the landlord. That, my lord, sets out the mischief, if you like, that Parliament was seeking to correct. The very next page, page 1807, I'm going to summarise this, if I may. The Attorney General, having recently visited Barbados, where there are still chattel houses, drew the distinction between the tenant who builds a structure which could be easily removed from the property because it was built on blocks. You would simply then have a truck attend, use a crane, put the house on the truck and then drive it away and put the house in another location. That is what didn't happen in Trinidad. And then, having circulated the photograph, and this is the top, second paragraph, forgive me, of page 1808, the Attorney General says this: the crisis which developed in Trinidad particularly is, as you know, that over the years tenants started building concrete structures which are so attached to the ground that it was impossible to remove them at the end of the tenancy. And that is why we got into this peculiar problem in Trinidad today. That is why we have got this problem that we are dealing with in this bill. And then dealing with the principles of common law that have passed into law in Trinidad and Tobago, skipping the next 7 lines, the Attorney General says this: everyone knows how widespread and deep-seated the practice of tenants building houses on the lands of their landlords has been in Trinidad and Tobago. It is as old as the abolition of slavery and the introduction of the indentured system in this country. With the progress of time, the movable one-room houses have given place to irremovable dwellings of steel and reinforced concrete, but the law has lagged behind, failing to catch up with and to reflect the realities of today. Part of that reality is that the value of lands and houses has considerably appreciated because of investments by government in infrastructure in the form of roads, water, electricity, etc., as it exists. And then, this hasn't copied quite right, but page 1809, the bill seeks to change the common law rule by virtue of the special majority so that the buildings will be divested from landlords and vested in tenants, and that the persons who sacrifice an investment bringing the structures into existence, the tenants would benefit.
I think it's quite clear what the general idea was. Is there any reference to the position of statutory tenants?
No, my lord. There is no reference to statutory tenants saying they are either excluded or included.
When he talks about common law rules and the common law and so on.
It does. May I deal with that now? If the intention of this act was to change the common law rule preventing a landlord taking the benefit of the land when the house is constructed on it, it is perverse to say that it would exclude statutory tenants who had done exactly the same thing. What would be the reason for keeping them out? There would, in my submission, be no reason, my lord. It is either a permanent change in the law or not a change at all.
This bill, according to column 1813, was the product of research by the Law Reform Commission. Was there a report?
My lords, I tried to obtain it. I was unable to. I'm afraid in my access to resources, I was only able to get the extracts from Hansard. There was a report, and I think it is referred to in the debates that there was some research carried out. It also suggests that there was consultation with land tenants associations and so on. But whether in fact they considered the precarious position of the statutory tenant, I do not know. But certainly in the debate, there is nothing to suggest that statutory tenants were specifically to be excluded. It seems that Parliament didn't even think about it.
Well, we shouldn't really be looking at these at all then, should we? It's not within pepper and heart.
Well, my lord, I say it is within pepper and heart because to construe this act as depriving a land tenant who's in the position of a statutory land tenant defeats the purpose of the 1981 Act. if only to demonstrate that Parliament did not intend to exclude them, then looking at Hansard at least confirms that.
I mean, are we going to spend time? There's not going to be anything there to find, is there? I mean, once we know they're not mentioned.
Well, I've made the short point, my lord.
I mean, I can see what your point is, that they speak in generalities and there's nothing to show that they ever thought that they were excluding from the remedy people who were statutory tenants. And you say that presumably there were a lot of them in practice.
There were. And can I, to deal with the, again, my Lord Rogers point, the bottom of page 1810, bottom left-hand corner, again dealing with the intention of the bill, last 12 lines, so that not only do we give thousands of the tenants throughout the nation benefits from the hard work and sacrifices they made to construct these houses, but we ensure that the bill, if accepted by this Parliament, would perpetually safeguard these thousands of people by placing a clause therein to ensure that straight away they get a 30-year lease, and at the end of each lease they have a renewable lease. They have an option to renew that lease for a further period of 30 years. The effect of it is a lease in perpetuity. And then I hope to deal with my Lord Walker's point. The third paragraph, down from there, where the chattel building is not owner-occupied, the landlord is under no restraint as to what he may charge for the rent, because, of course, the government has a duty to protect these tenants, and it has to ensure that nobody else benefits except tenants. So, my Lord, in construing the intention of the bill, there is nothing to say that statutory tenants ought to be excluded in any way, shape or form. My Lord, the very next page, page 1811, bottom of the page, last 6 lines, and this is dealing with the effect of the intended clause. The effect of that is that you have literally bent backwards to ensure that the tenant is protected, and these are the important words, at all stages. If the tenant is to be protected at all stages, it is perverse to say the statutory tenant is excluded. My Lords, the question has been asked, and I've tried to deal with it in my submissions on the definition of tenant. Can I invite your Lordship's attention very briefly to page 1816. Now, this was the original draft of the bill, page 1816, middle of the right-hand column, where the Leader of the Opposition makes this contribution. The definition of tenant on the same page means, tenant means any person entitled in possession to the land, either A, under a contract of tenancy. Now, I invite your Lordship's attention to this particular provision, because as it appeared in the original bill, the clear intention was to focus on a person entitled in possession and then create categories, one of which was a tenant under a contract of tenancy. It did not, I accept, end up in the final act, but there is nothing to suggest that it was not intended to be read in the way I've suggested. And then the next paragraph, question put. I should like to ask my learned friend one other question. What happens to a tenant at will? In our law at the moment, there are legal terms such as tenant at will and tenant at sufferance, and these are the important words, and things like that. It is unfortunate the Leader of the Opposition didn't explain what he meant, like things like that. But the short point, my Lord, is that this was offered as a potential inaccuracy in the legislation. The way it was then dealt with, my Lord, if I can take your Lordships to tab 5, page 1879. Second paragraph, last sentence, after discussing the point that was mentioned in relation to tenants at will and tenants at sufferance, the Attorney General said this: so that does not affect this bill as such. The bill as drafted will protect tenants at will and sufferance without any change. The pilot of the bill considered that the definition of tenant was so widely drawn that you didn't need to specify tenants at sufferance and tenants at will. This again is where the Court of Appeal perhaps understandably fell into error, because they felt that because tenants at will and tenants at sufferance were specifically catered for, that must be quite significant, because it then means that other tenancies are excluded. It didn't. The intention of the bill was to be as wide as possible. But before I move to the next part, my lord, can I take your lordships to page, it's the same page, bottom of the page, 1808. So 1880, 3:40 p.m., bottom right-hand corner. As we stated, Mr. Speaker, this is a bill to protect and assist tenants up and down the country, and certainly not to assist landlords. Well, my lord, if that is the intention of the bill, then a landlord could frustrate the intention of the bill by serving a notice to quit when the passage of this bill was going on, and avoid the effect of it, creating a statutory tenancy, and the tenant, having built his house, would have nothing. This bill was to prevent that.
Does the Law Reform Commission in Trinidad still exist?
My lord, I laugh because I've tried to contact them and they don't appear to exist, but I'm told officially they do.
Speaking for myself, I would like to see it.
My lord, I will try and obtain it. I did try to put it in to my bundle of authorities, but I was unable to. I can make a note of that, my lord. I'll try again to obtain it for your lordships at the conclusion of the hearing. The very next page, top of page 1881, and this explaining what the tenants did and why the bill was intended to protect them. The tenants, of course, did provide the structures, and they were improved over a period of time. Again, a clearer intention there could not be to protect the tenant who built their own structure on the landlord's land.
Well, I mean, I think you've shown us these. Is there any particular passage? You've already told us there's nothing that bears directly on the point.
I have to accept, my lord, and I do, that statutory tenants are not mentioned. But in inviting my lord's attention to Hansard, if the intention of the bill is to protect land tenants who'd built their own properties, the short point is that it can't exclude statutory tenants. The purpose of the bill is defeated. The purpose of the act is defeated. The act, the tenant having added value to the land for which he is solely responsible, cannot be outside the definition of tenant in the 1981 Act. If it is, then by default, if not by design, the landlord gets a gift of a substantial property. Now, in this case, my lords, and I don't know whether your lordships have seen the photographs which I've made available. I'm not going to take your lordships to them in any detail, but your lordships will see from the photographs that this is a property which cannot be removed without destruction. It has concrete foundations, steel beams supporting the wooden house above it, and the steps are concrete. There's also concrete guttering, a water line, drainage, electricity. All of this was installed by the tenant. If the landlord is to take possession of this land and simply compensate for the house, the benefit to the landlord is substantial. This bill was designed to prevent that. My Lords, I ask your Lordship's indulgence, if I may, to deal with this particular case, page 1884, in the same tab 5 of Hansard. Lest it be suggested that modest properties are not covered, middle of the page, 3:50 p.m., the Attorney General continues, the position of tenants who had built shacks on the land and who wished to renovate or even rebuild, recalcitrant landlords who would not sign plans as required by the local authority, this bill attempts to deal with that situation. So even if you don't have a substantial property or an expensive property, like the appellant's property in this case, this bill is still designed to protect them. I want to draw, if I may, a parallel. There are some properties, my Lord, some cases which are pending, where the properties themselves are substantial concrete structures, some having 4 or 5 bedrooms. These too fall into the category of statutory tenant. It is not, as the common terminology is used in Trinidad, possible for the tenant to break his house and go. And that is the terminology which even features in this case. The landlord says, break your house and go. Well, it's not possible to demolish houses of this kind. If statutory tenants are not included, then the gift to the landlord is substantial and not intended to occur. My Lords, the last part I will take your Lordships to is page 1890, bottom of the page. And again, it deals with the same point about how tenant is to be approached in the legislation. Bottom right-hand corner, we see again, tenant means any person entitled in possession to the land, and category 1 is the contract of tenancy. Other tenancies include something else. So, as I say, there is support for the proposition that entitlement in possession is not confined to a contract of tenancy. And if your Lordships look at the very next page, this is where the Attorney General makes the concession. This is to meet the comments of the Leader of the Opposition when he said that tenants at will and tenants at sufferance were not included. This provision would specifically include them. But your Lordships will recall the attitude of the Attorney General that the Act as framed covered them anyway.
I mean, it's quite interesting. I mean, if one looks back to tab 4,
Yes.
as I understand it, if you look at column 1803 to 1804,
Yes.
that's exactly where they deal with the rent restriction. That's where they put through the Rent Restriction Reenactment and Validation Act.
No,
Because went through the House of Representatives on the 20th of March, 1981, which is the same date.
Yes, I think, my Lord, this is the Rent Restriction Dwelling Houses Bill, not the Validation Act. This is the act that the respondent was referring to, that I have explained relates to dwelling houses, not land tenants.
It was having a busy time when they were putting. No, it went through on the 24th of December 1981. Or maybe not. Maybe.
Well, this is the second reading, my Lord.
Yeah, the sent on that.
Yes, it received assent on that day, but the Rent Restriction Dwelling Houses Bill was debated, second reading, order for second reading made on that day.
Yes, but I'm looking at the. If you look at the top of it, I mean, the vote on the rent restriction bill committed to whole House bill be now read a third time. It was after that that they went on to the rent restriction dwelling houses bill.
Oh, forgive me, my Lord. I see what your Lordship is referring to. Yes, I accept that. I accept that. I thought your lordship was referring to the words in bold. It's, yes.
All I'm saying is, I mean, they must have had rent restriction in mind since they'd just been dealing with rent restriction.
Oh, my lord.
I don't think it's a point against you. I'm just
Very well, my lord. And finally, I promise, my lord, I'm going to keep this very short.
We've had about 3 final points on this, Hansard. I hope this really will be the last, because I don't think we're getting much out of it.
No, no. Your lordships have this in the bundle. I'm going to stop dealing with this now, unless your lordships have any further questions on it. In my submission, it can't be clearer that this Act was intended to apply to land tenants. And if that is not clear from Hansard, then it won't get any clearer if I say anything more about it. My lord, the next... I was dealing with the case of Edwin Alexander. I'll just complete that.
I'd find it very useful if at some stage you could go back to the 1954 order, because I'm very puzzled as to why you give such a limited effect to that. It looks as if it was quite a complicated scheme for gradually shifting different tranches of property out of the scope of the 1941 Act.
Yes, yes. My lord, your lordships have the extract, I think, from Hansard for this particular order. The order itself...
Well, I'd rather look at the order itself.
Yes,
if
well,
you explain what your point is, why you say it doesn't have any relevance.
My lord, the simple explanation is this. When your lordships look at section 2, this deal with what the erection of a new building means.
Well, sorry, you actually took us to the schedule. I mean, the important part of the order is paragraph 2. The classes of premises described in the schedule are excluded from the operation of the Act. And then we look at the schedule.
Just bear with me for a moment. Tab 3. Sorry, my Lord Walker was looking at section 2 of the order.
That plus the schedule.
Yes. Yes. Section 2 simply sets out, I don't think it's controversial, what is going to be excluded.
No, that's why paragraph 1 of the schedule doesn't have a main verb, because it's simply a description of a sort of property, and it goes on like that.
Yes. And the order itself, section 2, is simply an order made under section 4.1d of the originating Act. Forgive me, my Lord, I didn't quite understand my Lord Walker's question.
Well, my question is that your learned friend says that if the house that we're concerned with was built before 1950, was built after 1954, it would have been excluded by paragraph 1 in the schedule. And I think he might go on to say, now he's had more time to think about it, that if it was built at any later time, it was probably caught by one of the other paragraphs in the schedule.
Yes. I understand the point being made, and I say it's wrong for this reason. Section 2b in Schedule Part 1, which is supposed to apply here, the entire order does not apply to land tenants. It applies to building tenants. It doesn't contemplate anywhere in the order that it applies to those who are renting land. The basis...
I don't understand that. Every building has a bit of land with it, some curtilage, however small. I don't see where you get that from this text.
Well, I suppose it's based on... It is based, my Lord, on my reading of 2b. I have tried to find an authority on this. There is nothing I can find. But this order, as it has been applied, as your lordship see from the case of Dehaney, doesn't apply to land tenants. And this is where the distinction is to be drawn, and has been drawn in Trinidad, between those who rent a house from the landlord and those who rent the land. It is particular and peculiar, as the Attorney General said, to Trinidad, because very often what the tenant would do would say, look, I'd like a place to live, can I rent your land from you? They would then rent the land and build their own house. The only thing they would pay the landlord for was a peppercorn rent, if you like, $16 a year, going up to $200 a year for the land only. The landlord doesn't contribute anything in preparing the land for building. He simply rents the land.
We understand that, but the 1941 Act applies to building land. There is a definition of building land in Section 2.1 of the 1941 Act. And contrary to what you told us earlier, the building tenant seems to be used not only for a tenant who is under an obligation to build a house, but a tenant who is permitted to build a house. It seems to cover both those.
Sorry, you're saying my lord is saying the order covers?
No, I'm saying, I asked you this morning what you meant by land tenant.
Yes.
And you gave a particular answer, which I noted.
Well, my lord, I'm slightly confused because, with your lordship's question. But if I understand the question correctly, the only submission and answer I can give your lordship is that the rent restriction exclusion of premises order, insofar as it applies, does not bring within it land tenants, people who did not build, who built their own homes.
And can you explain that point to me, why it doesn't apply to land tenants, whatever that means?
I can. First and foremost, you had the extract in Hansard where it contemplates...
No, we're looking at a statutory instrument. I don't want to look at Hansard.
Very well. Section 2 of Part 1 of the schedule, which explains for the purposes of this part, and then goes on to explain what the erection of a new building means. But then it goes further, B, and it's part B that I rely on, that the erection of a new building shall be deemed to have been completed on the date on which the first tenant or occupier enters into possession of the said building. Now, applying that literally, as I submit it must be, it contemplates the tenant going into occupation of the building as the tenant, not of the land. And that is the answer, I hope, to my lordship's question.
Sorry, can I have it again? I don't follow that.
You're saying that paragraph 2b contemplates that the building has been built by the owner of the land.
By the owner of the land. That is the point. Your lordship expresses it better than I. But that is as this order has been understood and has been applied. I'm not... So
I can understand it with tenant, but you say occupier also excludes the owner, for example.
It does. First tenant or occupier enters into possession of the said building, because this order is designed to apply to tenants, not the owner of the property. If the property goes into occupation of his own property, he has no difficulty under this order.
You see, I won't go on about it, but it simply doesn't fit in with the definition of building land in Section 2 of the 1941 Act, which is being excluded. It would be excluding, on your interpretation, it would be excluding premises which had never been in the Act at all in the first place.
Yes. That is essentially the point. I mean, building land, my lords, just looking at the definition of building land on page 5, tab 1, means land let to a tenant for the purpose of the erection thereon by the tenant of a building used or to be used as a dwelling. If this order, and perhaps I can put it this way, if this order was intended to apply to building land, then it would have specified that it applies to building land as well as as well as what is set out in Part 2B, and it doesn't. There's a clear distinction drawn between land which is rented and buildings which are rented. My Lord, I can't take that point any further.
It's concerned with premises.
Yes.
So, I mean, 4D is premises.
Sorry, 4D.
Of section 4D, specified premises and classes of premises and so on. And this is premises.
Sorry, my Lord,
4D, section 4D of the Rent Restriction Act, which is the power under which this order is made.
Yes.
Isn't it? 41D.
41D, yes, I have it now. I didn't have that in front of me a moment ago.
That's why it's called exclusion of premises order.
Yes. Well, it's drawn widely, my Lord. It's designed to exclude any range of things. So it can be restricted or limited depending on what the order contemplates. So, essentially, my Lord, it can't apply to a land tenant who's built his own house. There is, as I believe I drew to your Lordship's attention a moment ago, there is an authority on this, which is one of the cases I'm seeking to distinguish. And in Dehaney...
Oh, perhaps we should see that
yes,
at 2 o'clock. How are we faced for time, Mr.
My Lord, I'm in your Lordship's hands. I am...
Well, we've got to give Mr. Rhodes an opportunity.
My Lord, I'm going to be quite quick, because if your Lordships are with me in relation to the 1981 Act, I don't need to address you on anything else. And if your Lordships will indicate whether you wish to hear me on the other point, I have one other point to raise, and that's the limitation point.
I think we've discussed that in advance. We don't propose to hear you on the Limitation Act. We're satisfied it comes too late.
Very well. Then, my Lord, as far as the 1941 Act is concerned, I can adopt what is set out in my printed case. If the 1941 Act still applies, then the appellant is protected. If it does not, then I'm in difficulty. I did draw to your Lordship, I did put in the bundle the case of Ali and Ali, and the single sentence submission is that if it is the fault of the court in listing the case, which has resulted in the 1941 Act not applying, and it took 8 years for this case to be listed, adopting again a purposive approach, your Lordships could hold that the 1941 Act applies. The case is Ali versus Ali. It deals with a rather different matter, but effectively Ali versus Ali says that if by virtue of a procedural matter a litigant is deprived of his rights, the court will not hold that against him.
So I mean, you've got something more to say on the 1981 Act, is that right?
My Lord, no, I think I can...
Well,
I think I've covered everything.
We'll not treat you as having sat down.
No.
It's not an invitation to extend your submissions if you feel you are satisfied after lunch, but we can proceed on the basis that we will very shortly get to Mr. Rowe. Is that right?
Yes.
Thank you very much.